Good evening and welcome to the evening exchanges. It has been a long day and we have been discussing rights of children from different angles. And this evening panel, that is followed by some food. So I think that it is a good motivation to stay. This evening panel will concentrate on a topic that has been on the media agenda as well as on the agenda of numerous human rights institutions for the past few years. Children in migration and their rights is the topic of this panel. Just to give you some background, then of course you know about different migration crises that concerns children. But also the CRC committee in 2017 adopted two general comments on children in migration. UNICEF last year declared that 2018 is the year where problems of children in migration will be solved, and hopefully by the end of this year there will be no children that face trouble during the migration process. There has also been a positive or interesting development from the CRC committee that in January this year decided its first case in substantive on substantive matters on merits, and this case concerned a mother and a child from Somalia. And the committee stressed that the state party is under an obligation to refrain from deporting the mother and the daughter to Puntland because the child was at risk of genital mutilation. So there have been very different but different and important developments in these last years. But today we will be concentrating on the rights of children in migration and more particularly whether they have the right to participate. And we have a wonderful opportunity to hear first a keynote speech by Helen Stalford, a professor of law and director of the European Children's Rights Unit at the School of Law and Social Justice, University of Liverpool. And this is then followed by a panel discussion. So Helen, please, the floor is yours.
Thank you so much for coming out at this time of the evening when you should all be having your dinner, in my view. So I'm really grateful to Marit and the team for inviting me to your conference as well. It's my first time in Bergen, and it's just been a really, really informative and inspiring conference so far. I'm sorry I haven't been able to come to the whole lot, but I've left my own children separated in Northern Ireland while I've come over here. So my paper is essentially about the treatment of unaccompanied children in the UK who are going through the process of claiming asylum. And I'm looking at it through a children's rights lens, and particularly children's right to have a say in decisions that affect them. And it's based on a paper that's going to be published next month in the Journal of Immigration, Asylum and Nationality. And it's also based on some findings and thoughts that came out of two funded projects from the last couple of years. The first one is called Children's Rights Judgments, and some of you might be familiar with it. Some of you here have been involved in it even. And it's a project that was published last year in a book that was launched at the UK Supreme Court, and it has involved basically 60 academics from across the world who have revisited judgments that we just think weren't decided in the right way. And we decided in a very arrogant way that only academics can do to rewrite the judgments in the way that we thought that they should have been written, conforming to all of the sort of judicial conventions of that particular jurisdiction, and using sources from the time that the judgment was originally decided, but we decided to do it through a children's rights lens. And that book basically critiques the way that judges deal with children's cases and suggests a new approach to those judgments. So if you're interested in a sort of different methodology of looking at children's rights, that might be of interest. The second project then is one one that's funded under the same funding call that the IDEA project's funded under, that Connor and Kenneth talked about earlier in the team. And it's called Training and Assistance for Legal Experts. We finished this project last year. It was headed by Save the Children Italy, and it was really designed at providing training for legal practitioners who work with children, really trying to plug that capacity gap that so many legal practitioners have, because certainly in the UK there is no training for practitioners who work with children, save in very specialised areas. And one of the key areas that we were looking at was immigration and asylum. And immigration lawyers don't have any special training on how to work with even the most vulnerable groups. They have to have a higher level of training generally, but that is not specifically focused on working with children. So there, if you wanted to look at the online tool that we've developed, it's all based on the experiences of young people who have been going through the system. So we consulted with children as they were going through legal cases. We asked them about their experiences. We asked them to reflect on gaps in their experiences, and we also consulted with a group of young people who had been through some kind of justice proceedings. And so there's bits of video footage on the tool to inform the training. It's all very, very much grounded in the experiences of young people. And they're the different kind of modules that we develop based on what young people identify as the gaps and need. Okay, that's what the online tool looks like. So if you wanted to go online and have a look at what we've done, then you're very welcome to. It's freely available to everybody. Okay. So as most of you will know, children's right to participation is most famously expressed in Article 12.1, and just in case you don't know the content of that provision, here it is. And it's the most, I guess, celebrated provision of the UNCRC, and it's probably one of the most violated as well. And it's often referred to as the silver bullet of children's rights. It's through enabling children to have a say in decisions about their lives that we can activate so many of their other human rights and prepare them for a life as fully independent rights holders through childhood and as they progress into adulthood. Now, there's a vast literature on children's participation on the one hand, and there's a vast literature on child migration on the other hand, but there's been virtually no attempt to bring these fields of inquiry together in any kind of detailed, critical way. Hilda Lyman, who's here, has done some really interesting work here, but I was trying to kind of take a critical look at Article 12 in the context of asylum. Now, it's kind of curious that participation hasn't been looked at in an asylum context or in a migration context more generally, given that the weight to be attached to children's views is a crucial aspect of migration proceedings and certainly migration decision making. It's becoming increasingly apparent that decision makers really need to engage with children's accounts of their experiences in order to conduct a rigorous assessment of all immigration applications, not just those involving separated children. And in a UK context, this is explicit. It's an explicit obligation in Section 55 of our Borders, Citizenship and Immigration Act. That requires all immigration authorities to take into account the welfare of any children affected by any immigration claim, even if the child is not the claimant. Now, in what is still the leading authority in this area, Lady Hale, the President of our Supreme Court, asserted in ZH Tanzania that children's welfare must be determined by reference to the best interests principle enshrined in Article 3, and that determining what is in the child's best interests depends to a large degree on the readiness of the authorities to hear directly from the child. But despite this explicit correlation between the welfare obligation, stroke best interests, and hearing directly from the child, there's little evidence that children are heard directly in immigration proceedings of any type. There's even less evidence that their wishes, views, and feelings inform decision-making in any constructive way. Migrant children's entitlement in legal proceedings is largely parasitic and on and conflated with the claims of their parents. Consequently, children are typically portrayed in legal and public discourse as mere mobility facilitators. They're portrayed as passive, invisible appendages, or as silent accomplices to legally suspect forms of migration. So it remains the case that children's rights and interests are at best social and political afterthoughts in migration decision-making. Even where children's rights are foregrounded in a migration context, particularly in claims for asylum, such issues have been framed within a strong child protection narrative, located within what I would say are highly paternalistic, often decidedly opaque interpretations of best interests and welfare. Now, the conceptual and evidential gap around participation in immigration decision-making is most alarming where a child migrant is forced to pursue a claim in his or her own right, in isolation from any other family members. So the participatory experiences of unaccompanied children present particular concerns because children are placed centre stage of a process that is so ill-accustomed to dealing with children on a sort of autonomous, direct basis. Now that's compounded by the fact, what Maya was talking about earlier, that the asylum process is underpinned by an international treaty, the 1951 Refugee Convention, that actually makes no explicit reference to children, and by a jurisprudence that has struggled to depart from largely adult-focused interpretations of its asylum criteria. But participation is all the more important for this group of children, not least because in the very common absence of any documentation or supporting evidence, the outcome of a child's case rests so heavily on the child's own testimony. So with that in mind, I'm going to map out briefly the nature and scope of children's participatory rights under immigration law and policy in the UK. What does it say about children's participation? And then I'm going to refer to some of the empirical evidence, including our own research, on how that actually plays out in asylum proceedings. Then I'm going to look at how children's views are actually weighed up in asylum proceedings, particularly where there are concerns around credibility. Ultimately, I want to argue that we need to reappraise what compliance with children's participatory rights actually requires in an asylum context, and suggest that Article 12, as it's currently framed, is completely ill-adapted to this specific group and the particular process as we have it. So, just as a little bit of a context, we all know that there has been a surge in migration, and that surge in refugee migration in particular has elevated children, insofar as they are unaccompanied and intensely vulnerable, to a special status in public and political consciousness. And it's generated a much heightened level of concern and arguably much greater legal and policy accommodation in recent years. And it's certainly been impossible to ignore the devastating, destabilising effects of the refugee crisis, for want of a better term, on children. It's uprooted them from their communities, cultures, schools and friends, and significantly disrupted, if not totally severed, close family ties, and it's rendered hundreds of thousands of children stateless. Now, according to EU and EEA-wide statistics, in 2016, over 63,000 unaccompanied and separated children claimed asylum in the EU alone. Now, this has decreased by almost a half in 2007. And here's the table. So the green line are applications for asylum by unaccompanied children across the EU and EEA states in 2016. The blue line is in 2017, so we can see a halving of asylum claims almost across the board. Over the same period, I'll sort of break down some of the stats for you so you can see them more clearly in a minute. But over the same period, 3,175 unaccompanied children claimed asylum in the UK, accounting for approximately 4% of all claims across the EU. Now, the UK changed slightly because in the last quarter of 2016, we saw a sudden rise in the number of unaccompanied children entering the UK, which was largely triggered by the closure of the Calais camp and the launch of an operation to transfer some of those children, approximately 1,200 children residing in Calais who were unaccompanied. So there was an operation to transfer some of those to the UK, so that skewed the figures slightly. And if you wanted to just look at a kind of proper breakdown, I've just highlighted the countries that might be of interest to you. So Norway just had 175 applications from unaccompanied children this last year. Contrast that with Italy, which had just over 10,000. Germany, which was always the kind of favourite destination for asylum seekers in 2016, they've got less than a two-thirds decrease in asylum applications there. Sweden as well, prior to 2016, it was again a highly favoured destination for unaccompanied children and a dramatic increase in the last couple of years. So in the last year alone, we've had just over 2,200 applications for asylum from unaccompanied children in the UK. Now, there's been a corresponding upsurge in these legal and policy initiatives at international, European and UK domestic level, and no doubt in your own jurisdictions too, to respond to the plight of unaccompanied children. And that has been overwhelmingly concerned with achieving minimum standards of protection, facilitating burden sharing between the different states. And children's right to be heard is a really, really important part of that architecture, given that there's so little research and so little attention on children's participation. It's actually really, really evident in the legal framework. So at international European level, children's right to be heard is expressed as children's right to legal information, their right to advice and representation, their right to the support of a guardian or other representative to assist them through the different stages of the process. It's also manifested in procedural measures to minimise trauma for children who are going through asylum claims. It avoids repeat interviews or excessive delay, child-friendly adaptations to the physical environment, so interview suites and the like, and tailored training and capacity building for practitioners to ensure that they are equipped to respond to the distinct vulnerabilities of unaccompanied children. So when you look at it in paper, there's a really clear correspondence between the legal framework and what we would see as child-friendly justice. Now, if you drill down to UK domestic law and policy, there's an abundance now of domestic policy and law related to child asylum seekers. Now, this law and policy all says that children's participatory rights, their wishes, their feelings, shouldn't only be heard, but should also be acted upon at all stages of the asylum and child protection process. Specifically, the UK, in its most recent safeguarding strategy on unaccompanied children, says that all children need to be protected from harm, their views heard and acted upon, and to have consistent support provided for their individual needs. Guidelines for Home Office officials also say that all children over the age of 12 should be interviewed so that we can provide an opportunity for the child's voice to be heard directly. Interviewing officers in the Home Office are obliged to ascertain the wishes and feelings of the child in discussions relating to their return to their country of origin. And the same obligations are mirrored in statutory guidance for local authorities on the care of unaccompanied children and victims of modern slavery. The wishes and feelings of the child are an important guiding principle informing decisions concerning their treatment and placement. So that's the Department for Education document there. All of those measures in turn reinforce a more general statutory child protection policy which covers unaccompanied children in the same way as any other child under local authority care. Wishes and feelings should be not only listened to but acted upon. Now significantly, and this is very explicit in the safeguarding strategy, all of that is framed very explicitly within the UNCRC, which endorses a distinctly children's rights-based participatory framework for the development of services for unaccompanied children. There is much UN guidance on how that can be achieved as well, as many of you know. Now, so far so good. It's all looking great on paper. And all of those provisions are, of course, welcome, necessary, well-intentioned. But they operate on the fundamental presumption that it's in the interests of the child to be heard in the asylum process, that the views of the child hold some currency in determining whether they meet the criteria for international protection, and that the primary motivation of decision makers is to uphold the child's interests, that there are no other factors at play. All of the empirical and jurisprudential evidence that I've looked at that pertains to children's participation in asylum proceedings tell us that such obligations are heavily compromised by a political and economic agenda that is totally ill-disposed to children's rights. So let's have a look at some of that evidence. A review of all of the most recent research, certainly in the UK and beyond, but in the UK primarily, on unaccompanied children's experiences of asylum, reveal that even the most extensive participation provision on paper offers absolutely nothing in the way of a guarantee of its quality or indeed of its compliance with Article 12 as we understand it. I think it's fair to say that children's right to be heard is more poorly implemented in asylum proceedings than in almost any other legal subcontext that I've looked at. There's an absolute abundance of evidence pointing to participatory deficiencies at virtually every stage of the asylum process, from initial screening and reception, from social work assessment and family tracing, through to care placement, access to schools, and appropriate accommodation. But to say that children are not heard or muted across all of those stages only reveals part of the picture. I think the problem is rather more nuanced than that. It's not so much that children are not being heard, but that the conditions under which they're being heard and the agendas and methods that are driving those encounters are heavily compromised. Perhaps most worrying than not being heard is the sinister turn that I think hearing children is taking, particularly the notion of giving due weight to children's views. The way that that has taken this sinister turn in asylum proceedings to actually undermine rather than enforce children's rights. So I want to consider the particular brand of participation that's being levied in an asylum context and really look at who its beneficiaries are. I think the first thing to be aware of is that children's participatory experiences need to be evaluated within the procedural context of the various stages of the asylum process. And I think when we talk about participation and the critiques of participation, really need to tease out what the participatory expectations and opportunities are in each of those stages. It's really, really critical that we understand the context of the stages. In brief then, in the UK, the asylum process begins with a claim for asylum being lodged with the Home Office. Now, usually concurrently with that, a short welfare interview, it used to be called a screening interview, but now they call it a welfare interview, is normally conducted when the asylum claim is made. And the purpose of that screening or welfare interview is threefold: to ascertain that the child wants to claim asylum, to collect basic information as to the child's identity, where they've come from, when and how they arrived in the UK and what documents they have. And thirdly, to identify and attend to the child's immediate welfare needs. Now, the Home Office subsequently conducts a more detailed, substantive asylum interview with the child, usually after the child's had some food and a rest. And that's to assess the child's claim. Now, the default position, as we've already heard, is that all claimants aged 12 or over will be interviewed at this third stage. There are various possible outcomes of these kinds of assessments, but up until, I think, the last 6 months or so, the majority of claimants have received a temporary status in the UK. That's called unaccompanied asylum-seeking child leave to remain. Now, that UASC leave to remain has accounted for approximately 50% of all claims. And what that means is that the child is granted a leave to remain for a period of 30 months or until they're 17 and a half, whichever is shorter. And at that point, when that's expired, the child will have to make another application to request leave to remain for a further period. But the majority of those who get UASC leave are then deportation proceedings follow and they're asked to leave. Now, those that are refused, and that's between 11 and 17% from any quarter to another, can appeal to the Asylum and Immigration Chamber of the Tribunal. And of those that appeal, approximately 25% are overturned on appeal. So it's worth appealing. Now, insofar as many children seeking asylum never actually set foot inside a court or tribunal, a key testing bed for compliance with Article 12 lies in children's experiences of Home Office interviews. So the first 3 stages. I think many of the concerns raised about these kind of procedures and children's participation are within the context of the Home Office dealings with children. So I want to talk about how the Home Office abuses unaccompanied children's right to participate in a very reductive way. Empirical evidence, coupled with my analysis of the case law, points to basic procedural failings by Home Office staff that not only undermine but also abuse children's participation. For instance, staff are known to unlawfully engage children in discussions around their substantive claim at the welfare or screening stage of the process, often in the absence of appropriate adults and legal representation. Such testimony, unlawfully and prematurely obtained, has then been used against claimants to support rejections. This immediately places children on the defensive at the most fragile stages of their migration journey and potentially hampers more positive efforts to ascertain what their basic welfare needs are. Research also suggests that substantive interviews, that's the third stage, perform a rather different function than what we envisage in Article 12. That's less about giving the child the opportunity to have a say in how decisions and how different aspects of their claim might be disposed of, and more about giving the child the opportunity to defend their right to make a claim at all. Evidence gathered by the Law Centre's network in 2015, following their analysis of 60 unaccompanied children's cases, revealed a lot about the techniques of immigration officials, and our work in the TEAL project has absolutely reinforced these views. It tells us that even with all of the subsequent policy, these techniques still persist. So these techniques include the use of vague, confusing and closed questions, a failure to explore significant aspects of the child's migration trajectory that might actually support their claim, inappropriately timed, intrusive and insensitive questions probing, for instance, the child's sexuality, intimate relationships and experiences of abuse. This, the research claims, has perpetuated a system whereby things are being done to these children with little or no seeking of their opinions, thoughts, feelings or desires. There's overwhelming evidence of hostile interrogatory procedures and ineffective safeguards during Home Office interviews. And that was a big feature of the research undertaken by Wilding and Denball in 2015. Child respondents that they spoke to talked of feeling attacked and intimidated, being asked multiple questions repeatedly, seemingly in an attempt to expose inconsistencies in their accounts, with limited or no opportunity to draw on the support of an accompanying adult. Now, the potential of these direct encounters with Home Office decision makers to compound children's vulnerabilities and perhaps even distort their claims is heightened by the trauma and complexity of the child's migration history. We all know that the sheer horror and psychological impact of unaccompanied children's experiences are now pretty well documented. And it is widely acknowledged that such experiences militate against a comprehensive, chronological, coherent testimony. Because of past trauma or ongoing fear, children may be simply incapable or unwilling to express their views freely. Ravi Kohli, in his interviews with 29 social workers in relation to 34 cases involving unaccompanied children, revealed a lot about the silence, secrets and types of truths children tell about themselves to both help and hinder their search for resettlement. Now, much of the withdrawal and silence exhibited by these young children is attributed to their inability or unwillingness to recall painful and traumatic events. But there is also some evidence that it is part of a healing strategy, a quest to become autonomous, in much the same way as many adolescents, in normal circumstances, maintain secrets and silence. Kohli also points to evidence of children relaying well-rehearsed versions of the truth, usually under the instruction of parents, agents, or other successful refugees, in an attempt to, and I quote, squeeze their stories into the narrow channels acceptable to asylum givers in their chosen country of refuge. Such stories, Kohli says, favour thin narratives of victimhood that fit well within legal constructions of the refugee child, in preference to what are thick, ambiguous, multi-layered and complex realities that encompass both ordinary desires, relationships and experiences alongside extraordinary suffering. Elaine Chase, in her subsequent study into the emotional well-being of 54 unaccompanied children seeking asylum in the UK, points to widespread reticence to share crucial aspects of their personal histories, not just with professionals charged with aspects of their care, but with significant people in their lives, including friends, foster carers, and medical staff. For them, what to disclose, to whom and when, is the only aspect of their immigration journey over which they felt they had any control. Their wishes are expressed not through words, as Article 12 implies, but through their silence. Now, all of that does not bode well in a process that is defined by legal categorisations, contingent on the availability and persuasiveness of detailed factual accounts. I want to talk a little bit about the second component of Article 12 that we so often neglect to really think about in enough detail, and that is how much weight is attached to the testimony of children. We know that the true currency of child participation in any legal process, including asylum, is contingent not just on the procedural safeguards, but on the weight likely to be attached. Quite simply, poor participatory process tends to lead to poor outcomes for children. So let's just remind ourselves, I'll come back to that in a second, what Article 12.1 says. The The views of the child should be given due weight in accordance with the age and maturity of the child. That formula of itself presents serious challenges in an asylum context if we consider that as our framework, as our kind of gold standard. First, to what extent can we realistically expect children's expressed wishes and feelings to be acted on in the face of the stringent legal and evidential requirements associated with asylum claims? The second thing, then, is the way in which children's evidence, age and maturity are actually weighed counterintuitively to justify a refusal of their claim rather than to inform what is best for them. Specifically, rather than supporting credibility and persuasiveness, which is what Article 12 envisages, the older and more mature unaccompanied child runs the risk of not actually being believed to be a child at all. I want to talk about those in a little bit more depth. What children want is relatively easy to fathom in asylum proceedings, but it's rather less easy to achieve. They want the safety and security of long-term residence in the UK. Achieving that, of course, depends on the extent to which they fulfil the 1951 Refugee Convention criteria, and that hangs not on subjective expressions of desire or aspiration, but on verifiable objective testimony, whether the child meets the evidential threshold. The child's views and wishes are only relevant insofar as they are supported by that evidence. I looked at all of the upper tier and appellate case law since the Supreme Court decision in ZH Tanzania, and there is virtually no judicial engagement with children's expressed wishes and feelings, let alone explicitly with Article 12. So, due weight in asylum claims turns on whether the decision maker actually believes the child's kind. I've already referred to the difficulties of many unaccompanied children in presenting sufficiently detailed accounts. Perhaps more problematic, however, are those who operate at the other end of the spectrum, not because of their silence, but because they reveal rather too much, perhaps inaccurate or partially evidenced information, often in a misguided bid to please authority figures or to secure a swift resolution to their claim. Now, the process of attaching due weight to the child's views take on quite a different, more negative, sinister construction in this context. So due weight here is attached not so much to the humanely ascertained wishes and feelings of the child, but to inconsistencies, inaccuracies, teased out through what are highly adversarial and often confusing cross-examination. Now, that credibility test permeates the entire refugee status determination process because adverse credibility findings provide the basis for the majority of failed asylum claims. In such cases, the participatory opportunities afforded by asylum processes might not actually serve to enhance children's agency at all. Instead, they can reinforce abuses of power, subvert children's voices, turn children's voices in on themselves in a perverse act of self-sabotage. The potential for those in power to abuse this therefore entrenches the denial of any real voice to children because there's everything to lose and not much to win in expressing their wishes, feelings and experiences. So, what do we do to manage participation in a more constructive way? Well, the full paper talks about, I guess, three things. First is managing the participatory conditions. Why do we need to insist on repeated direct interviews in this particular context? Why can't we have participation at a distance through carefully controlled witness statements? There is often absolutely nothing to gain unless you want to put a very articulate or a particularly heart-wrenching case before a judge or decision maker, but the risks are really, really high. The other strategy is limiting the admissibility of evidence, and the courts have talked about if there is procedural unfairness, then the decision maker has to basically ignore that evidence if it's not been obtained properly. But the problem with that is that it's very difficult to unsee and unhear the evidence that's been provided. And the third is challenging undue weight, and particularly having a liberal application of the benefit of the Dyke principle. Now, there's a lot of guidance on the benefit of the Dyke principle and the way that concessions should be made for children who might have inconsistencies in their account, gaps in their account, that they should basically give the child the benefit of the doubt. But I think there are a couple of real fundamental limitations to the benefit of the Dyke principle. I think the first is that we have a particular image of the way that the unaccompanied child should look and appear. And that is something that is massively compounded by media representations of unaccompanied children, with which the media has been particularly complicit. Now, if you look at this kind of heartbreaking image of 3-year-old Syrian boy Alan Kurdi drowned whilst attempting to cross from Turkey to Greece with his family, we need no explanation, and it prompted absolute global outrage, and it certainly prompted a change in policy direction in the UK. Now, these representations, according to McLaughlin, hinge on the problematic notion of the universal child. We have the foregrounding of child victims, which has produced a humanitarian narrative of crisis built on the politics of innocence and vulnerability. At the centre of this media spectacle is the iconic figure of this very vulnerable child, the embodiment of the very quality of innocence, and that is seen to define our unaccompanied children. I contrast that, this is just from the 10th of April, with the first wave of children who came in following the Dubs Amendment, which was seeking to resettle children who were floating around Europe. Here we have a particularly unchildlike child, and that represents the majority of the unaccompanied children that are falling before the Home Office. Now, the problem is that the benefit of the Dyke guidance and the case law has reinforced the first image, and it hasn't quite caught up with the second image. We have this selective and somewhat superficial synthesis of what is in fact an expansive, sometimes inconsistent and by no means conclusive body of clinical and empirical evidence around the trauma and how that manifests itself in unaccompanied children. So we've got new stereotypes that are being perpetuated by some of this benefit of the Dyke guidance. We've got new stereotypes that don't do any favours whatsoever to the majority of claimants who don't exhibit these typical traits ascribed to these unaccompanied children. I think the problem with the guidance that we have as well is that it seems to be predicated on what is in fact a highly contradictory body of evidence, and a vast body of evidence, which is synthesised into what I think is a crude pocketbook of developmental psychology that is then put before decision makers to apply to any unaccompanied children. In fact, what we do know is that psychological research shows that the demeanour of either adult or child witnesses is a doubtful indicator of reliability. There are few specific behaviours or mannerisms that are reliable indicators of deception. Children, like adults, may be reacting to the stress of the courtroom. They may be reacting to the stress of their family situation. They may be body language and other forms of behaviour are culturally prescribed as well. So, I think if you want to see more, you can read it in the full version of this paper. But I think what I've tried to expose is this very awkward fit between current articulations of children's participatory rights and the reality of the unaccompanied child process. I think I'll leave it there and just allow you to be able to kind of...
I now invite all the panelists up here, and then I will introduce the panelists, and I have given them quite free hands in the sense that those who want can comment on the keynote speech presented, but also as we have here a variety of expertise, then they are also they have the right to expand on the topics and discuss further what kind of problems children in migration face. So let me first introduce you the panel, and I'm going alphabetically, so not to discriminate against anyone. And we first have Maja Janmer. She's professor in international migration law at the Norwegian Center for Human Rights, University of Oslo. Then we have Katrin Griggs, sociologist from the Emmanuel College, Boston, US. Then we have Hilda Liden, a social anthropologist researching migration in the Institute of Social Research in Oslo. We have Nicholas Oragon, a legal scholar from University of Nairobi, Kenya. We have Sagrario Segado, a psychologist from the National Distance Education University, Spain. And we have Hugh Tobon, social work researcher from University of East Anglia, UK. And I will now give the floor to each of these panelists, and then we will kick off with panel discussion and accept also questions from the audience. Maximum 7 to 8 to 10 minutes, or not more. Around that, yeah. Maja, you are first on the alphabetic order.
Yes. Thank you. Oh, I need to have it.
Yes.
Can everybody hear me? Sort of, okay. I can't really hear what's on and off, but yeah, you can hear me, that's fine. Thank you so incredibly much. I feel so privileged to be included in the panel on child rights, coming from a very international refugee law perspective. And as you pointed out, Helen, international refugee law doesn't really take a child rights perspective, especially not when we look at the Refugee Convention, which is the legal instrument that I'm most familiar with. I thought I would just raise two quick issues or comments here that sort of align a little bit with my own work in this regard. I've worked a lot on the humanitarian response when it comes to Syrian refugees in the Middle East, so that's primarily what I've been working on. I'm thinking that this non-engagement of the Refugee Convention when it comes to children, the child perspective, also has trickled down to the United Nations High Commissioner for Refugees and its approach to children. As you pointed out also earlier, it's clear that UNHCR also terms its engagement with children more as a child protection perspective rather than a child rights perspective. And we can see this even looking at the basic guidelines that UNHCR has developed when it comes to this. And I'm thinking that this says something important about agency and about vulnerability, and how these two concepts sort of, is there a tension there? Is it a negation of agency in a sense? So I was just wondering from your perspective, how can we reconcile these notions of agency and vulnerability when it comes to the child's right to participation in asylum hearings? Is it possible, and how should we do that? So in a sense, lessons for UNHCR. And to me, I would say that UNHCR's non-focus on child rights rather than child protection is worrying, considering the fact that in the countries that I work in, mainly in the Global South, where there are no national asylum procedures, where it's mostly also the UNHCR that is conducting the refugee status determination procedures. So there are no studies, to my mind, on the child's focus when it comes to UNHCR's RSD procedures in these countries. And if you know of any, please enlighten me. Otherwise, I would suggest that that is a very interesting line of inquiry further. Related to this, and also you mentioned in one of your last slides the notion of vulnerability and the role of the vulnerability concept here. In the Middle East, and especially in regards to the Syria, what we call the Syria crisis there, we see an increased use of vulnerability assessments rather than asylum procedures being used. So we see how vulnerability is being used as a screening procedure to determine access to protection as a whole, and not the asylum claims that lie underneath. So I was just wondering also if you see a similar trend in the UK. In the European context, we can see this in some parts. For example, I'm thinking of Greece, where you have asylum seekers stranded on islands, and only those who are the most vulnerable get access to the Greek mainland for a proper asylum determination procedure. So I'm just wondering if this focus on vulnerability rather than rights and asylum claims is something that we also see in the European context. I'm sure others can reply to these questions as well. Thank you.
Thank you. Thank you.
Thank you. I'm dropping my wisdom.
Sure. There it goes.
Hi, my name is Kathy Grisch, and as Katrin said, I'm a sociologist, and Katrin's quote-unquote marching orders / instructions were to comment on Helen's presentation from the viewpoint of our professional disciplines. But I have to say, you're a very hard act to follow. So thank you. This is super interesting. I feel like I learned a lot. I should probably also say that I'm an immigrant in the United States. I've lived 25 years of my life in the US and 25 years of my life in Austria. And I just came here from Austria via the United States. And I can't tell you how glad I am to be here in a country that's not the United States or Austria. Right?
Wait till we tell you about our migration.
Maybe afterwards. What I wanted to talk about, what I thought about, what is it that I can meaningfully talk about as a sociologist? And I was thinking of the sort of wider structures that our understanding of children's rights, and especially the right to participation, of the wider social structure that they are embedded in. And we often talk about institutions or instruments of socialization. We talk about the family, we talk about schools, we talk about peers, friends, and the media. And even though I'm not a scholar of the media, I wanted to tell you a little bit about a very small-scale analysis that I did just very recently when I was in Austria about the media coverage of the left-wing United States media on children's participation, on children's migration experiences in relationship to the issue of family separations, which I don't want to go into because I don't want to take up your time with this. So what I noticed, I looked at articles from left-wing media because I thought that would be interesting, that meaning center-left. That gives you an idea of what those media that could potentially educate, socialize people into thinking about children's rights and children's participation and the role of children in migration, that they could potentially be instruments of socialization. I read articles, about 30 articles total, by the New York Times, the LA Times, the Washington Post, and CNN. And what I noticed was very similar to what the scholars you mentioned noticed, was that the understanding of children was very one-dimensional. And I would like to fall back on my discipline and a scholar who is probably not very fashionable anymore, but His name was Herbert Marcuse, and he talked about the one-dimensionality of certain concepts. And that means that concepts that have revolutionary potential, like children's participation, like children themselves, they lose their revolutionary potential. Like, for instance, when you think of Enlightenment music, like Mozart, and you hear it on the elevator, and then it totally loses its revolutionary potential for you. It's become one-dimensional. And when I read these newspaper accounts, I feel that this is what has happened to the concept of migrant child. So I just Googled migrant child in all these different newspaper outlets and found that they were not only very adult-centric in the sense that the extent of the accounts were focused on the experiences of adult migrants, but they also focused only on children's experience in detention. They did not acknowledge that different children have different migration experiences, that they have different experiences in detention and deportation. There are over 100 quote-unquote shelters, detention centers in 17 states in the United States. So I found the coverage to be very narrow. I also was trained as an undergraduate as a social linguist, so I noticed the language that is used, also the language in legal discourse. And I noticed that one of the terms that I saw for unaccompanied minors was unaccompanied alien minors. I was a documented immigrant and not a citizen in the United States, but when I was a green card holder, I was always referred to as a resident alien. And I always thought of myself as somebody, if you think of an alien, like Planet of the Apes, so I don't know what, like with little things, blue hair, but I don't know what. And I thought this did not reflect the way that I felt about myself as an immigrant. And my story. And this reminded me of the presentation of the children and young people in the Veränderungsfabriken from this morning, who talked about how language is so important to them, the way in which professionals talk about them, that they are not a sock, a client, but that they are a child or a young person. So I would also call for linguistic rectitude, I would call it, and I'm borrowing from somebody who's called Daniel Goldhagen. Linguistic rectitude in the way that we talk about children who are migrants. Thank you very much.
Thank you. Hilda.
I'm a social anthropologist and have done research or evaluations of hearing procedures in the Norwegian immigration authorities, and that is what I want to say something and reflect on. And also the gap between the real intention in the Norwegian Immigration Act to have a child-sensitive approach, and then the lessons learned from praxis and the challenge to implement this in the procedures. So to ensure that the national regulation of immigration were in accordance to the CRC and in line with the Norwegian Human Rights Act and the Constitution, the Immigration Act of 2008 included provisions and formulations intended to strengthen the legal position of the asylum-seeking children as children. And so the Act states that every child is a right holder as on its own, also children in families, and the child should have a lower legal threshold to obtain asylum based on refugee status. And the regulation include instructions on child hearing in the asylum procedures. This is the intention in the Immigration Acts. And all accompanied minors from the age of 7 are entitled to a child conversation with the immigration authorities. And for families, the conversation is voluntary, but every child in the family is encouraged to participate. And it's quite a big percentage that participated in this child conversation. And for unaccompanied minors, they are entitled to an asylum interview, similarly to adult asylum seekers. So it is the same procedure as the adult. And a legal guardian supports the minor during the application process, the whole process. So this is the intention, and this is the way they are organized. And vital to the hearing procedure is the expertise to identify child-specific forms of persecution, as we have discussed, and factors that may limit the inclusion of adequate information about children's situation are in the assessment really numerous. And one example is for the accompanied minors that even if they are interviewed, the main focus is still the parents' case, and if they come with information that are important for the child, for the asylum ground, the case is still very much on the parents' case. And also we see that the knowledge on children and also the experience to interview children is quite insufficient. And one aspect I have been especially interested in and see as a very important is that the limited knowledge on child-related topics among caseworkers. There seems to be a rather superficial understanding of the multiple ways that children are affected by, participate in, and experience armed conflicts and other relevant aspects. So they have no sufficient knowledge to have following up in questions and to get this essential information and details to include this as evidence and to use it in the assessment. So I think that instead of really going into this assessment of their situation, they are instead of assessing the vulnerability, and that is one of the why they are doing that, more than discussing the rights of the child. And also, additional challenge is that the hearing procedures is mainly limited to one interview, asylum interview in Norway, and it's an early stage in the procedure, in contrast to the UK procedure. So I think that is also additional information may harm the argument more than important and credibility. to unaccompanied minors. That is the age assessment, as you mentioned. And the limited options, they have to inform the decision when the age test, with all its limits, as we know, says that he or she is maybe over age. And so in this case, they are not really heard and not included in the arguments. The decision is taken by the case worker. Yeah.
I just looked at the time and
Yeah.
it is moving fast.
Yeah.
So can we pass on to Nicholas? Yes. I'm so sorry. It's really moving faster than I suspected.
Okay, because the only I'm feeling very fortunate to be here and all the other women the other side. So I present you this particular panel.
I was thinking of the gender balance here, so and is it the female issue that the migration poses to the society? Thank you for being the
Okay, thank you.
minority representative.
Thank you. I'll be very fast because of time. Katrin said that UNICEF says that 2018 or by 2018 we'll have a solution for all the problems of migration and children in the migration process. And despite all the efforts of the United Kingdom, Helen says that there's still problems in all aspects of, or all the places where children have to be in relation to the migration process. So I asked myself, her presentation was David versus Goliath, but how do you defeat Goliath at the very source, so that you do not have the challenge of pitting David versus Goliath in the migration process? So I thought I'd look at that, but before I look at this, I want to ask a question. Is there an international migration crisis, or is there a European migration crisis? And if you look at the statistics show that migration has not really increased that exponentially. The UN, NISA, IOM, and UNICEF actually, the data that they have actually shows that migration has not increased that exponentially. What has really increased, and you can even see the number of children only increases in relation to the millions of people that actually migrate. So what has increased actually is the political and societal tolerance of migrants, and because falsely or not falsely, migrants are said to have difficulties in integrating, or they create a situation where crime becomes rampant, or they just create a security situation. So the problem really is not that migration has increased exponentially, it's just that people have become a bit more intolerant to migrants, including societies that were actually built by migrants. So what are the sources and destinations of migration, and why do people actually get to migrate, and where do they get to migrate? Statistics also from UNICEF and IOM shows that 2/3 or 72% of international migration is actually to high-income countries, and 1/3 of migration is to middle-income countries. 8 in 10 migrants will actually move to a country, if they're leaving their country and they're crossing a border, they'll move to a country that has a gross national income of at least 20% beyond or higher than what they have as a country. And only 3 in 100 migrants in high-income countries actually came from low-income countries. So it's not the European migration crisis, the American migration crisis. It's actually not being caused by low-income countries. Then Africa and Asia actually bear the burden of migration, international migration. Asia has 39% of migration, child migrants, or child migration generally. Africa has 21%, Europe only has 18%, and North America only has 14%. And 3 of every 5 children that actually move to a country that is not within Europe and it's not within North America, it's actually within either Asia or Latin America. And if you look at migration generally and where people move to, only 2.3 million people in 2016 moved to Africa. Why is it people not moving to Africa who are not within the African region? Actually, only a few Asians and Europeans are moving, but only moving to get rich. As Trump said, to get rich in the shithole countries. So, what are the complexities? What are the complexities that we see? Why do people migrate? Because if you're going to solve the migration situation, I'm not saying we are going to create Wakanda everywhere where low-income countries are. But what are the reasons why people migrate, and what is the potential? What is the potential threat of child migration if these sources of migration are actually not dealt with? We see that we have globalization and inequity in the global geopolitical system. We have population pressure, poverty, inequality, and lack of opportunity. And we find that 400 million children live in extreme poverty. If 400 million children decided to move to Europe, that will be a crisis. Then you see displacements, conflicts, persecution, lack of human security, forcing people to move. 28 million children are actually displaced, and 12 million of them are refugees, meaning they have crossed an international border or asylum seekers. And the other situation that causes people to migrate is environmental degradation, natural hazard threats, and disasters, as well as the situation we have with climate change. 7 million children are actually displaced due to natural hazards or disasters, and that's happening in only 1 year in 2016. 500 million children live in places that have extreme flood risks, and 160 million live in places where drought or the threat of drought is extreme. And in relation to human trafficking, 28% of victims of human trafficking are actually children, girls and boys equally. So if you don't, or if we don't respond to this particular situation, we have not yet seen a crisis. If all these children in all these situations decided to move, there will be a crisis. So how best do I think, or how best should we approach this particular situation? I think the best interest of the child is to have the child actually stay in an environment or a country where they're born, where their family is, where their support structures are. And how are we going to be able to achieve that? By ensuring that all the necessities of life and all the opportunities and safety is guaranteed in those particular places where those children are born. And what's the long-term strategy? Each and every long-term strategy has to deal with the key issues that actually cause migration in the first place. Under development, hazard vulnerabilities, climate vulnerabilities. And this has to be done in a very, very comprehensive and integrated manner. So what's the challenge? Internationally, we have different frameworks responding to different issues that can be integrated to actually ensure that there is sufficient programming at the places or the sources of migration to be able to deal with these situations at source and to stop the migration at source. My responsibility in the next 2.5 years is actually to try to see how we can integrate disaster risk reduction and disaster risk management, climate change adaptation, climate change mitigation, and sustainable development within the UN Vision Agenda 2030 framework to actually create a system that can respond to the situation or the sources that actually create the migration or the need for migration, which is underdevelopment, hazard vulnerability, and climate vulnerabilities in a way as to not to achieve the UNICEF goal in 2018, but in the near future. Thank you so much.
Thank you.
Yes, so Daria, you're next. I think that also this mic should work.
first of all, thank you so much for this kind invitation. I have enjoyed a lot this morning, and I'm enjoying a lot this afternoon. I'm learning, so it's wonderful. Okay, I'm going to speak about Article 12, the situation of the unaccompanied minors in Spain. In Spain, the idea that the child has to be heard has become a very serious and important matter. The starting point is coming from us, the Article 12 of the UN Convention of the Rights of the Child. The Convention notes that this right is not limited to the children being heard, but being listened. Their opinions can be followed or not, but necessarily whoever adopts it will have to justify in a reasonable manner the reasons taken into consideration for making such decision. In the General Comment number 12, in paragraph 21, the Committee of the Rights of the Child underlined the concept of the child as a bearer of rights from the earliest stages. The full application of Article 12 would require the recognition and respect of non-verbal forms of communication, such as play, body and facial expression, drawing and painting, through which very young children demonstrate the ability to understand, choose, and have preferences. And this is a very relevant fact in the case of migrant minors. The right of the child to be heard has deep implications. One that touches me a lot is that the concept of belonging of children with respect to adults disappears. Disappears in a very brand new way, because the child belongs to himself or herself, and he or she is a subject of right whose interests must be taken into consideration in all decisions that affect him or her, and whose opinions must be heard before determining the concept of their interest. In Spain, the last two laws of 2015 that modified our main child protection law that was active in 1996 are mainly characterized by the essential, fundamental, and principal role that has the voice of the child. The law makes clear the importance of the child being listened as the main vehicle that guarantees the participation of the child in the decision-making process about him. And what about the hearing process of our migrant children? According to our law, a migrant child is first of all a child and afterward a foreign. Thereof, migrant children are under the child protection laws and not the immigration laws that are extremely restrictive. And this is the case. In fact, in the databases where the interventions on child protection are registered, it is not specified if the child is a migrant or not, as a way of pointing out this universal character of the condition of minor. I'm not going to make a special reference to the migrant children who are not alone, because their listening process develops normally, understanding that this process needs to be improved a lot in the country. There is a strong search for standardized forms of effective listening that could also be applied to the whole Spanish territory, since there are many differences between the regions. Because in Spain, all the competencies on child protection have been transferred from the state to the regions, so children are in charge of the regional governments. But in relation to unaccompanied migrant minors, things are different. The condition of unaccompanied minors required by a law that in no more than 9 months, children get a residence permit. In practice, this permission, I have read it never comes, but I would say that it comes from time to time, which is something more scary maybe. What happens is that these children get a kind of tutelage or guardianship from the regional administration. And these minors are not cared by the local social services of family and minors who care for the rest of the children in my country. The rest of the children are native children and migrant children who are not alone. They are cared by child protection services at the regional level. As an example, I will tell you that we do research in Melilla. Melilla is a Spanish city in the north of the African continent, and it is considered too as a region at the administrative level. Melilla is the entrance of the 98% of the unaccompanied minors who enter into my country every year. When we interview these minors, there are two fundamental wishes, desires, or things that they want. 80% of them only want one thing. They want that we let them go to some location in Europe where they already have family networks or friends waiting for them. But this is a tricky issue, because can we let these children go alone? We cannot, because we have to protect them. At the moment, our form of protection is not listening to moms, is to place them into specific care centers and try to give them the most normalized possible life. I have to say that it's not been a success, because it is very difficult to normalize children who have been crossing the African continent, in some cases, for some during years. 70% of the cases end up with the flee of the minors from the centers to continue with their migratory trajectories. The other 20% want to stay in the centers to obtain citizenship and work. In the Spanish case, 80% are Moroccan. They flee from poverty. They have had a very, very poor life, but in some way kind of normalized life, because they have lived in family. They are able to remain at the centers for this reason. And when they are asked what they want, they say what I told you, that they look for a residence permit and a possible Spanish citizenship upon reaching the age of majority. In theory and legally, it should happen like that. In practice, it only happens from time to time. Why? Because the call effect, who he says it doesn't exist, but you know the political explanation about the call effect, or to discourage the migration influx. In conclusion, in any case, for both of those who say, both for those who say that they want to stay and for those who say that they don't, there is no satisfaction in what they ask. Hearing the voice of the child is not giving them what they are asking or demanding, but it is to explain them why we are not giving them what they are asking, and it is to explain to society why we are not giving them what they want to, and it is to state in the reading reports of every single case why we are not giving to that child the thing or the desire that he is demanding. Finally, I want to stress the importance of working towards the definition and establishment of criteria and minimum guidelines that maintain a certain homogeneity in terms of the determination of participation of these children, the role they have, and the respect that should be given to their wishes and feelings as essential part of the decisions. Decisions that in any case have to be flexible and verified case by case.
Thank you, Sakaraya. And last but not least, June.
Start with England and end with England.
And we have 6 minutes left, yeah?
Yeah, right, okay, I should be quick. My background is social work, and my research has always been around the socio-legal, and I'm particularly interested in the interplay of child welfare legislation with immigration legislation. I'm also incredibly proud to say that I was Ravi Kohli's PhD supervisor. We didn't know that, we only just met. So I would recommend that book. But I'm also a political animal, really, and I was struck when you reminded me of Ravi's work, which was completed 10 or so years ago, of the deterioration in the position of unaccompanied asylum seekers in England. And some of you might have followed the issue of the Windruffs generation in England, where we've been deporting children who came across as British citizens from Europe, and we've from the Caribbean, and we've acknowledged that we have had, originated by our present Prime Minister, a hostile environment, deliberately acknowledged hostile environment for refugees, and that of course has had a huge impact. And add to that what we've all got is austerity. So that I think that we are going backwards in terms of the way we treat unaccompanied asylum seekers, but also children who arrive with their parents. This hostile environment has meant that we have done almost what the USA has done, actually, by deporting parents and saying to the child welfare authorities, you can take the children into care. And that has presented huge dilemmas for the social workers who, by definition, should be refusing to take children into care. So just to complement really what Helen said about how the system works, as soon as the child is established as a child, the same day, in other words, they become children in need under the child welfare legislation, and they get exactly the same treatment under child welfare legislation as any other child. And that's a great strength of our system, because immediately they acquire a social worker. Ravi's book is very interesting because he really looks at the complexity of the social work role with these children. The social workers, if there are any amongst you, I think there are, like to take a social history. We base what we do on what the child has experienced. Ravi's book makes it very clear that the social workers in these circumstances have to suspend, they have to work without that social history, because they know that their job is not to say, are you telling me the truth? So whilst the immigration officials are saying, what's the truth? The social workers alongside them are saying, you're a child, we care about what you want and what you need. So Ravi talks about both high quality social work but also rather poor quality social work, because the social work is absolutely crucial to the unaccompanied as well as those with parents and the attitudes they take up. We've got some excellent children's legal centres, is a very good source of advice. We've also got Centre Article 38, which is also a source of advice on, for social workers to help them with the job. But basically, all social workers, broadly speaking, the under 16s come into state care, and the over 16s tend to not come into care, but are held under provisions for children in need, which all children in under 18 have. Now, social workers in England have huge discretion, actually deciding whether to accommodate a child under 16 or keep them out because they're over 16. Makes a huge difference, because if they come into care or are accommodated under 16 or at any age, they acquire rights to support until the age of 25, so they get the social worker fighting for them up to the age of 25. Except that under our hostile environment, in Ravi's day, the social workers, these youngsters were going to university, the social workers loved working with them because they were so rewarding to work with them. The local authorities who had refugee children, lots of them, were very proud because they had more children going to university than other people, and that's because these are youngsters who were really a delight to work with. But now, immediately 17 and a half, we're getting all the rights that these young people had acquired, living in foster families, good children's homes, suddenly all being challenged because, of course, they might arrive in their foster home at 11, they're doing well at school, they want to go to university, but at 17 and a half, all that is thrown up in the air, and you can imagine again what that does for the foster families who are trying to, because English children have a right to stay put in their foster families after that sort of right. But finally, there's a very interesting question in English law. At the moment, there's been a judgment that says, at the moment, all the refugee children come into what we call voluntary care. They don't go through the courts. The court system is on the whole for children who are suffering significant harm because of parental fault. Now, a recent judgment has said they should all be taken to court, taken through the courts to ensure that they have their rights. But of course, if they all went through the court systems are already flooded out. So it would immediately, certainly in certain parts of the country, flood out the system. And there is a question about whether the young people are asked, would you like your case to go through the courts, or would you like it to remain as it currently is? And I haven't heard anybody talking about asking young people that particular question, or indeed any information, printed information for social workers to help them discuss with their young people whether indeed they should be given legal advice that it will be in their interest for their case resolved by the courts. Okay, bit of a mixture.
Yes.